Hi, I wanted to cover some frequently asked questions on what's called the legislative privilege. So, what is a legislative privilege? It's basically a legal doctrine that creates an evidentiary privilege against giving evidence on official legislative acts. How does it compare to legislative immunity? Under that longstanding legal doctrine, legislators are generally immune from civil liability for their official acts in office. How does the legislative privilege work? In essence, the legislative privilege allows an elected member of a legislature to speak freely in debate without fear that the legislator will be sued for what he or she says, such as for slander. What's a parliamentary privilege? The term legislative privilege is also referred to as a parliamentary privilege because it originated in European parliaments. How does legislative immunity work? It basically protects a legislator from a civil lawsuit in cases of either a legislative act or the legislator's individual motivation for pursuing a legislative act. How does the legislative privilege work? Legislative privilege is a privilege for evidence purposes that limits the type of evidence and testimony at a civil trial. Why would these elected officials have this privilege? The privilege is meant to ensure that verbal or written statements made by legislators as part of the legislative business offers these elected officials an ability to engage in robust debate and consideration of different points of view. Where does the legislative privilege appear in California law? The privilege is codified in California Civil Code Section 47, which is a very lengthy section of state law if you review it. How have the California courts interpreted Civil Code Section 47B? The state courts have viewed it as an absolute privilege, which means that officials are immune from civil lawsuits for making certain statements as part of official proceedings. See, for example, the 1994 California Supreme Court decision in Moore versus Conliffe. Specifically, Section 47B1 of the Civil Code protects statements made in proceedings of all legislative bodies, whether state or municipal. This was a 1974 California appellate court decision called Scott versus McDonnell Douglas Corporation. Does the legislative privilege apply to non-legislators? Yes. The courts in this state have applied the legislative privilege to official legislative proceedings and have, for example, applied it to a witness's potentially defamatory testimony before a local government committee concerning a proposed ordinance. The California Court of Appeals said this in the Rizzo case, Rizzo. Also in Spittler versus Children's Institute International, a 92 California Court of Appeal decision. The legislative privilege may also extend in appropriate circumstances to non-legislators, the Court of Appeals said in Board of Supervisors versus Superior Court, 1995. And finally, what is the extent of the legislative privilege according to the state courts? Civil Code Section 47B1 provides protection for communications made in connection with proceedings of all legislative bodies, and again, it applies in pursuant to Civil Code Section 47B1 to a statement that bears some connection to the work of the legislative body. This again came from the Scott case that I cited earlier. So that's basically some frequently asked questions related to California's legislative uh, privilege.